did not know, didn't have a safety. I didn't know any of that. That's what I do. I'm trained to do that. Okay? Trained to kill. Okay? Trained to kill. That's what I do. But I'm trained to kill. That's what I do. Trained to kill. Okay? That's what I do. Kill. For a living. Okay? Illegal electronic. Trained to kill. Okay? It hurts. It hurts the people that are here now. Okay? Yes.
In my opinion, the outstanding closing argument from the prosecution attorney, Dave Young, was one of the best I have ever seen, and possibly sealed LS's fate. After watching Young destroy and completely discredit the only relevant witness the defense had, Dr. Dorothy Lewis, this was the next logical step. Young took us through all the points that demonstrated LS was using judgment and reflection with every single action she took on that day. Young starts off by saying Gannon's injuries are relevant not only to the crimes that she's charged with, the murder counts, but they're relevant to what her state of mind was when she committed those crimes. The burns the night before he was killed, the hydrocodone in his system making him lethargic, the stabbings, all 18 of them, the smashing of his skull 4 times, and then finally the 4 gunshots, one of which was fatal. Judgment, reflection. Young took us through the insanity plea timeline, how there was no evidence of any mental disorders, no history of inpatient psychiatric treatment, no history other than anxiety of any other diagnosis for mental illnesses, no evidence of psychosis, no evidence of dissociative identity disorder. On June the 5th, 2020, LS is heard saying, "I'm going to start acting crazy." On that same day, she enters a competency issue into the court, which starts the competency evaluations. The timing of that. Gannon's body was found on March the 17th. She found out about it on March the 20th. We know that she has read the discovery, the police reports in this case, and all of a sudden she starts acting crazy for another defense. What's relevant about this first competency evaluation that takes place on July 20th, 2022, is that when she goes to the state hospital for a 2-week observation period where she is being observed by nurses and employees, LS actually approaches one of the nurses and asks her, "Can you tell when someone is faking it?" Initially, she is telling them she has bipolar disorder, that she has manic depression, but nothing about dissociative identity disorder, which, even according to Dr. Lewis, she has had since a very young age. Dr. Gray and Dr. Torres diagnosed her with specified personality disorder with borderline and narcissistic features. No evidence of psychosis during that evaluation either. Then she starts talking about DID and bipolar disorder with Dr. Grimmett, claiming to have 4 distinct personalities and the ability to press a button in her cell that summons 2 vampires called Jasper and Justice right out of the Twilight series. This is not how DID works. Then the defense contacted Dr. Lewis, a world-renowned expert on DID. Before Dr. Lewis even spoke to LS, she contacted the attorneys and told them to change the plea to not guilty by reason of insanity. She hadn't even evaluated LS at this point. In the meantime, LS has created more personalities. LS claimed to have created them herself. Again, this is not how DID works. You don't create the alters. Dr. Torres already testified to that. They present themselves to you. Dr. Torres also testified that there is no credible evidence to conclude she has a condition that conforms to the definition of a mental disease or defect. Dr. Torres asked LS if she could speak to one of the alters, Maria Sanchez, and LS told her, no, Maria just doesn't come out. There's got to be some kind of stressor. There's got to be a triggering event. I can't just summon Maria. But when Dr. Lewis asks to speak to Maria, she just pops out. Dr. Lewis was the only one who managed to speak to any of LS's alleged alters. And when asked how she was able to do this, she replied, magic. Young then continued to discredit Dr. Lewis, who didn't even know the legal definition of insanity in the state of Colorado. She couldn't answer any of his questions on cross-examination because she didn't want the jury to know the answers. She showed up to court every time late. He even suggested she had narcissistic tendencies. He compared her to the other doctors who were able to refer to the correct terms in their answers. He also reminded the jury of the lies that were told by Dr. Lewis. The first one regarding further testing on LS to confirm her diagnosis of DID. When first questioned, Lewis told the court that they were declined further tests. But it was later discovered through an email written by Dr. Lewis herself that she had decided to withdraw the application for these tests. She told the jury that she needed these tests to make a decision. She never got the tests, but she still made the decision, and she still made a diagnosis. The defense really didn't have much to go on. The prosecution had already discredited their only witness. The only thing they could do is poke holes in the prosecution's case and maybe do some damage control regarding their main witness, Dr. Lewis. Mr. Tolini told the jury that the fire, which occurred the night before Gannon's death, was some type of trigger that had been, and I quote, disassociated long ago. He then took us through what he believed was a psychotic episode, with LS not sleeping and that she was manic. According to Colorado law, if the defense can provide a doctor's diagnosis stating their client was insane at the time of the crime, this then shifts the burden of proof for insanity or sanity back to the prosecution. This is what Dr. Lewis provided them. The prosecution rebuttal was just as dynamic as the closing, but this time it was Alan's turn to drive their point home and bring Gannon home. Alan started off by counteracting the defense's claim that motive had not been proven. Alan explained that they don't have to prove motive, but they did anyway. He goes through those points, starting with the reason she chose her stepdad's death for not coming into work that day. She needed an unassailable excuse because she knew what was happening that day. Gannon wouldn't play with fire. He would never go downstairs and just light candles randomly. This was the start of the attack, ladies and gentlemen. Sunday night, and it continued with hydrocodone. A prescription for a full-grown man was given to Gannon. Think about the manipulation that she carried out on everybody in her life. I would venture to guess that not a single one of us in this room ever even knew a fake polygraph website existed. I didn't. Let's talk a little bit about Dr. Lewis. She might be a world-renowned expert, but she is the only expert they could find to bring in here to tell you that this defendant has DID. None of the other doctors who testified here saw a single shred of evidence that she had DID. Not a single one. And yet this doctor comes in and says she does. Yet she doesn't even know what the definition of insanity in Colorado is. She starts throwing around words like McNaughton and other things that might apply in other states, and that sanity could depend on where you are, what state you're in. There were a lot of I assumes and I don't knows, deflections, and she was pressed to justify her opinion. She couldn't even do that. You heard Dr. Torres in contrast. She could point to specific things about the evaluation. Compare the two. It's Gannon's fault, right? He pooped all over himself, started a fire, experimenting with drugs. Isn't that convenient? He's curious about bath salts, and there are Swisher Sweets planted in his backpack. He's got hydrocodone in his system. Isn't this a convenient concoction from this defendant? Gannon was a mama's boy. Is that the source of her hatred for him? She could never replace that kind of love. So she tells everyone that he went to a friend's house and didn't come back. She concocts numerous wild stories, starting with Eduardo, some random Mexican guy. She just gives him access to the house through the garage code. He comes in to fix the carpet, but in addition to fixing the carpet, he rapes her, bangs her head on the floor. No sign of injury on her, curiously. You heard the nurse testify to that. He asked for boxes and a suitcase. She had to introduce the suitcase. She had to explain why Gannon was going to be found in a suitcase. Next, it is Quincy Brown's fault. He was real. He was on the most wanted list for sex offences. The perfect fall guy for what this woman did. He replaced Eduardo. She knew his name because his ID fell out conveniently and landed on the floor. Then he turns into the Craigslist guy up in northern El Paso County, selling a bike, or he's laying in the road as they're driving and gets into the car, forces them back home and rapes her. Or Gannon is test riding a bike, crashes, hits his head, and he takes off with Gannon. Then came Uncle Matt, who was high-fiving with Gannon before taking off with him. Then it's the pregnant lady with Cash Baby. Supposedly 8 months pregnant, involved with money laundering for Mexican restaurants. She gets into the car, starts pulling money out of her belly. The one thing that all of these stories have in common is that LS is always the victim. In every single one. This was a very calculated move. These stories were all made up to explain away why pieces of evidence were found in the case. She knows that the suitcase will probably be found. She notices that law enforcement was searching up in Douglas County where the board was found. So that's when the bike story comes in. She has to explain why her GPS is going to show up in that area. The most cruel of all blame shifting is when she brings Landon, Gannon's mother, into her stories. It's now her fault. She has taken him to Mexico. She even pointed the finger at Al, blaming him for Gannon's abduction because of money owed to the abductor. Lastly, it's the caped invader's fault. Standing on top of the bed, wearing a cape, she didn't realize it was Gannon and she shoots him, stabs him, and does all these other things to cover up. She realizes that all the other stories are not working, and this is where Dr. Dorothy Lewis comes into play. Before she even looks at a shred of evidence in February 2022, she's already said, yeah, you need to go with not guilty by reason of insanity. She didn't know a single thing about the case of the defendant in February 2022. She hadn't even met the defendant yet. So what does the defendant do now? She starts creating names. There's Taylor, Harmony, Christina, Jasmine, the Frisky Princess, Little Lucia, and Maria Sanchez, the Spanish-speaking Russian sniper, who knows how to kill. One thing we do know from this evidence is that this defendant knows how to kill. She knows how to kill a defenseless little boy in his bed. In that first story about the candle incident, she talks about taking the kids outside and then having to go back downstairs to get Gannon, and they all pile in the truck and drive off. Yeah, that never happened. That was just a story that she had to explain away because the fire didn't work. She forgot that Gannon was a fighter, a 1 pound 6 ounce little boy when he was born, overcame all the odds, but he couldn't overcome this one. But he sure did try, didn't he? She stabbed him 18 times. Most of those stab wounds were defensive wounds because he fought back. Then she beat him over the head 4 times with some blunt object that was never found, cracking his skull like an eggshell. Shot him in the jaw, severing his spine and likely killing him instantaneously. She then manipulated the heck out of the investigation with her stories and fled to Florida and South Carolina to get as far away from this thing as she possibly could. She was looking into escaping the country when she was finally apprehended. LS was found guilty of all charges. Colorado District Judge Gregory Werner sentenced LS to life in prison with no possibility of parole for the murder convictions, in addition to shorter prison sentences for the 2 tampering charges.
I could breathe for the first time. Sitting back and you have a 50-50 shot, right? It's one way or the other. And so when that guilty verdict and everything came out, I was happy. Like, it's one of those times, it feels like a little kid at Christmas time, if that makes sense, that you've waited so long and the day is finally here. So it was the best feeling. So.
I think my best way I can explain it is how I did in my statement. It's been really hard, and just open it up a little bit here. It's been really hard to access Gannon throughout these past 3 years, and hopefully I can start doing that a little bit more now that this part is behind us. That's really for me kind of just a weight lifted off, another weight lifted off, and I can start experiencing my son a little bit more as time goes on.
My goal is that she's been convicted now and sentenced to life in prison without parole. Let's get her off to her last place here in Colorado, which is the Department of Corrections, where she'll serve the rest of her days in prison.
I pray that we will never have to look at her face again, said Landon. Justice has been served today. This won't bring my son back, but I can sleep soundly. Gannon, I never in my wildest dreams would have ever thought you'd be in danger, Al said. Or I would not have left you at home with what turned out to be your murderer and the last person to ever see you on this earth. I am so sorry. When a crime is committed out of jealousy or rage, then it is answerable to, Judge said on jury instructions. LS was moved from Colorado to Kansas to serve the rest of her sentence. The reasons for the move and the exact location is unknown to the public. In Colorado, where this case takes place, even if you committed a crime, the judge can give the verdict of not guilty by reason of insanity. In other cases, the court might alter the sentencing if you can prove that you were mentally impaired while committing the crime. But how does Colorado define insanity? To be found not guilty by reason of insanity, you must have been so mentally ill at the time of the crime that you couldn't tell right from wrong. The court could also allow this defense if the defendant could argue that they knew their behavior was criminal, but they lacked the capacity to control it. This is called irresistible impulse. A defendant is presumed sane until proven otherwise, and if some evidence of insanity has been presented by the defense, then the burden of proof shifts to the prosecution. It is the prosecution's job to prove sanity in Colorado. When the defendant makes an insanity plea, they still acknowledge that they were involved but were not of sound mind at the time of the crime. The insanity defense is classified as an excuse defense rather than a justification defense. The prosecution and defense can order their own mental health evaluation. If both sides agree on the outcome of the assessments, the case might not even go to trial. So how do courts test for legal insanity? The first approach is called general mental illness, which is a broad category that includes things like schizophrenia, bipolar disorder, and major depression. If you have a general mental illness, the court will consider whether or not your delusions or hallucinations stopped you from knowing that your actions were wrong. The second type of mental illness is specific intent crimes. These are crimes where there's a clear intent to do harm, like murder or arson. The court will look at whether or not the defendant had the specific intent to commit the crime, even if they knew it was wrong. If they find that the defendant didn't have the specific intent to commit the crime, they may rule them not guilty by reason of insanity. After a verdict of not guilty by reason of insanity, the court will sometimes send the defendant to the Colorado Mental Health Institute at Pueblo, CMHIP, for evaluation. The doctors at CMHIP will then determine whether or not the defendant is a danger to themselves or others, and if they need to be committed to a mental health facility. What is the difference between insanity and diminished capacity? The insanity defense is sometimes confused with diminished capacity. Although the defense known as diminished capacity bears some resemblance to the reason of insanity defense, in that both examine the mental competence of the defendant, there are significant differences between them. While reason of insanity is a full defense to a crime, that is, pleading reason of insanity is the equivalent of pleading not guilty. Diminished capacity is merely pleading to a lesser crime. A diminished capacity defense can be used to negate the element of intent to commit a crime. One of the most famous recent uses of the insanity defense came in United States versus Hinckley concerning the assassination attempt against then-President Ronald Reagan. How is insanity proven? In order to make an insanity defense work, the defense has to show that their client, the defendant, was insane at the time of the crime. In the legal realm, insane does not necessarily mean the same thing as what we might think of when hearing the term insanity. Under the law, if someone is not guilty by reason of insanity, they may not have been in their right mind when the crime was committed. In some cases, this defense may refer to a severe episode of mental illness, but not always. A defendant may be considered insane if they were pushed into criminal activity by political ideology or acting out after a traumatic event. The most crucial factor in the insanity defense is competency, otherwise known as competency to stand trial. In accordance with due process requirements, a criminal defendant cannot stand trial if he or she is deemed legally incompetent. As articulated by the Supreme Court in Dusky, a defendant is incompetent if he or she is incapable of rationally communicating with his or her attorney or rationally comprehending the nature of the proceedings against him or her. A defendant may move at any time for a hearing to determine competency, which involves the submission of supporting evidence and some form of a psychological evaluation. If the judge allows an insanity defense to stand, there may be a competency hearing to determine whether the defendant is legally incompetent. During the hearing, the defense has to provide evidence that their client is legally incompetent in addition to a psychological evaluation. The threshold for establishing competency is often identified as notoriously low, but the likelihood of the court accepting an insanity plea is even lower. So long as a defendant is deemed incompetent, the insanity defense becomes moot, as the defendant cannot stand trial. In most cases, the insanity defense is not the best course of action because it's difficult to prove, and the defense strategy may not convince the jury. In the legal system, case results can become precedent or the standard for specific situations. There are several precedents for the insanity defense that affect how the court handles these cases and the outcome if the defendant is found legally incompetent. The McNaughton Rule. The first famous legal test for insanity came in 1843 in the McNaughton case. Englishman Daniel McNaughton shot and killed the secretary of the British Prime Minister, believing that the Prime Minister was conspiring against him. The court acquitted McNaughton by reason of insanity, and he was placed in a mental institution for the rest of his life. However, the case caused a public uproar, and Queen Victoria ordered the court to develop a stricter test for insanity. The McNaughton Rule was a standard to be applied by the jury after hearing medical testimony from prosecution and defense experts. The rule created a presumption of sanity unless the defense proved at the time of committing the act the accused was laboring under such a defect of reason, from disease of the mind, as not to know the nature and quality of the act he was doing, or, if he did know it, that he did not know what he was doing was wrong. This analysis focuses on a defendant's cognition. The test is divided into two components, each of which is individually sufficient to substantiate an insanity defense. First, a defendant is deemed insane if they were incapable of knowing what they were doing at the time committing the offense. This conclusion comports with criminal law's fundamental conception of culpability. A defendant is not culpable for an act that, because of a psychological infirmity, he or she did not know he or she was committing. The second component of the test looks to determine if the defendant knew that his or her actions were wrong. Here, even if the defendant knew what he or she was doing, he or she is deemed insane where he or she was incapable of recognizing the wrongfulness of the action committed. For example, the defendant is often found insane on the grounds that because God commanded the defendant to act, he or she was unable to recognize the wrongfulness of the act that was carried out. Various legal commentaries have identified theoretical issues within the McNaughton framework. For example, a scholarly debate exists addressing whether the wrongfulness central to the McNaughton analysis comprises tenets of legality or morality. Another prominent criticism takes objection to the categorical approach the McNaughton test employs. By focusing exclusively on cognitive incapacity, the McNaughton test is not well suited for treating more nuanced forms of psychological disorders, particularly those involving volitional impairment. Traditionally, the McNaughton test has been associated with schizophrenia and psychotic disorders. The McNaughton rule became the standard for insanity in the United States and the United Kingdom, and is still the standard for insanity in almost half of the states. In contrast to the emphasis on cognition central to the McNaughton test, the irresistible impulse test focuses on the volitional components of insanity. Various courts have struggled to address criminal defendants who, while comprehending the wrongfulness of their actions, are incapable of self-control because of a mental disease or defect. To levy punishment against a defendant unable to control his actions appears at odds with the preeminent tenets of criminal justice. The move towards volition alleviates this tension. Under the irresistible impulse test, a jury may find a defendant not guilty by reason of insanity, where the defendant was laboring under a mental disease or defect that compelled him to commit the offense. This test is well suited for persons suffering from manias and paraphilias. While treating a genuine issue within the McNaughton framework, the irresistible impulse test creates several practical concerns. First, unlike the cognitive prong of the insanity defense, the volitional component of insanity is substantiated by a less robust scientific literature. Consequently, evaluating the veracity of a defendant's claim becomes more difficult in the absence of unequivocal scientific findings. Moreover, the irresistible impulse test may be over-inclusive. Defendants laboring under psychological conditions, which, while genuine, do not completely inhibit self-control, may be exonerated of criminal liability. Monte Durham was a 23-year-old who had been in and out of prison and mental institutions since he was 17. He was convicted for housebreaking in 1953, and his attorney appealed. Although the district court judge had ruled that Durham's attorneys had failed to prove he didn't know the difference between right and wrong, the federal appellate judge chose to use the case to reform the McNaughton rule. Citing leading psychiatrists and jurists of the day, the appellate judge stated that the McNaughton rule was based on an entirely obsolete and misleading conception of the nature of insanity. The Court of Appeals overturned Durham's conviction and established a new rule. The Durham rule states that an accused is not criminally responsible if his unlawful act was the product of mental disease or mental defect. The implementation of this test was initially seen as a progressive development. Specifically, the Durham rule moved away from legal formalisms and emphasized scientific psychological evaluations and evidence. This approach emphasized expert testimony and largely left the jury to follow the professional opinions provided. So long as a professional concluded that the defendant was subject to a mental disease, a finding of insanity likely followed. Problems quickly emerged, however, and the Durham test fell out of favor. First, the test revealed itself to be frequently conclusory and deprived the jury of their decision-making role. A finding of insanity was left to the discretionary findings of trained professionals who were largely unrestricted in their methodological approach. The lack of any clear definition for essential terms like mental disease or defect exacerbated this issue and led to inconsistency as different professionals came to disparate conclusions. Moreover, the test proved over-inclusive. Under the product approach, defendants could be found not guilty by reason of insanity even where they understood and had control over their actions at the time of the offence. For these individuals, punishment may be more appropriate as its deterrent effect remains intact. Consequently, the same DC Circuit that adopted the test in 1954 rejected it in 1972 when deciding the Brawner case. New Hampshire is now the only jurisdiction that employs a test similar to the Durham rule. In 1972, in an attempt to modernize the legal standard for insanity, the American Law Institute, a panel of legal experts, developed a new rule for insanity. This rule, found in paragraph 4.01 of the Code, says that a defendant is not responsible for criminal conduct where they, as a result of mental disease or defect, did not possess a substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. Section 401 of the Code represents a concerted effort to reconcile the various details and emphases present in the traditional tests for insanity. First, the language appreciate addresses the cognitive component central to the McNaughton analysis. Unlike the oft-rigid McNaughton test, however, the appreciate language of 401 is broad and intended to realistically address the graded nuances of mental disabilities. Moreover, the rule allows the legislature to choose between the language of criminality or wrongfulness. This presentation allows legislatures to choose between a more legalistic conception of wrong, in the form of criminality, or a broader, morally infused understanding in the form of wrongfulness. The evaluation of wrongfulness or criminality is complex and intricate. Complications arise, for example, when considering persons who, although knowing society would condemn their acts as wrong or criminal, believe that this would not be the case if society knew what they were aware of. The second component of 401 comprises a volition-based analysis. This aspect of the Model Penal Code's insanity standard reflects the theoretical foundation supporting the irresistible impulse test. Here, the Code dictates that criminal liability is unjustified where a defendant could not conform his conduct to the requirements of the law. This emphasis on conformity looks to provide for those persons cognizant of their wrongful act, but unable, because of some mental disease or defect, to control themselves. The inclusion of this volitional analysis alongside a cognitive analysis represents the progressive nature of the insanity standard developed in the model penal code. In 1984, Congress passed and President Ronald Reagan signed the Comprehensive Crime Control Act. The federal insanity defense now requires the defendant to prove by clear and convincing evidence that at the time of the commission of the acts constituting the offense, the defendant, as a result of a severe mental disease or defect, was unable to appreciate the nature and quality or the wrongfulness of his acts. This is generally viewed as a return to the knowing right from wrong standard. The Act also contained the Insanity Defense Reform Act of 1984, which sets out sentencing and other provisions for dealing with offenders who are or have been suffering from a mental disease or defect. In addition to these seminal understandings of the insanity defense, some legal theorists have endorsed alternative conceptions of the insanity defense in an attempt to address various weaknesses often identified. The integrationist approach, for example, does away with the insanity defense as a unique defense to criminality and evaluates individual defendants under traditional exculpatory defenses like duress or necessity. Yet another modification comes from the abolitionist perspective. Under this model, some scholars contending that social benefit can be derived from the punishment of persons often exculpated by the insanity defense have suggested the eradication of the insanity defense in its entirety. Max Vachtel, a forensic psychologist based in Denver, who has conducted several sanity evaluations in criminal cases in Colorado, said that it is actually incredibly common for two experts to have a difference in opinion on sanity reports in a criminal case. It comes down to a credibility contest. Which expert does the jury believe more? Vachtel explained, "I think it also comes down to money. Usually, you can find two credible experts who will conclude differently on sanity. What makes the Stauch case much more abnormal, according to Vachtel, is the major difference at which the two experts disagree. Vachtel explains that usually when sanity is brought up in a criminal case, it's because there is a clear and well-documented history of severe mental illness with the defendant, and that the existence of the mental illness is not disputed by the prosecution or its expert. Lewis concluded that LS was insane at the time she allegedly killed Gannon, and that she suffers from dissociative identity disorder, vastly contrasting with the findings of Dr. Loandra Torres, a forensic psychologist who works at Colorado's State Hospital in Pueblo, who testified for the prosecution. She was psychotic at the time, not in touch with reality, and I don't think she knew the difference between right and wrong. I don't even know if she knew what she was doing, Lewis said. Lewis claimed that during one of her interviews, LS had taken on the Maria personality, which LS claimed was the one who killed Gannon in an interview, and spoke with a Russian accent. Another unusual trait of LS's trial is the lack of evidence supporting a severe mental illness from the defendant, something Vachtel described as incredibly unusual for an insanity plea. Vachtel explained that often in cases where sanity is the defense, there will be major evidence to show that the defendant had a documented history of mental illness before the incident. It's really unusual, especially for somebody who is claiming dissociative identity disorder, Vachtel said. For that person to have never been diagnosed with PTSD or to never mention anything to a primary care physician, that's unusual. That's a huge hurdle the defense will have to get over. Dr. Luandra Torres told the prosecution one of the key reasons she found LS to be unreliable and one of the key reasons she didn't diagnose dissociative identity disorder was the lack of any of LS's family members claiming they knew of her multiple personalities. She talks about having this mental illness since she was 16 years old, and it's never repeated anywhere, Torres said. That's meaningful to me. Lewis, who said she didn't speak with any of LS's family members, testified during cross-examination that the importance of what the family says is less relevant to her because they have reasons to not be entirely truthful, as opposed to LS. I find what they do when nobody is watching is more impactful, Lewis said during cross-examination. One of the few points agreed upon by both sets of experts is that dissociative identity disorder, previously known as multiple personality disorder, is an extremely controversial diagnosis. Vachtel, who said he had diagnosed people with dissociative identity disorder in the past, stated that the reason for that is twofold. There are numerous people who dispute that dissociative identity disorder is even a real mental health condition, and defendants often lie about having it in criminal cases. Dissociative identity disorder is one of the most faked mental illnesses when it comes to sanity evaluations. If somebody is going to fake it, they typically either claim a fake psychosis or multiple personalities. If you appreciate my work on these documentaries, please consider supporting me. You can do that in various ways. Like the video to tell YouTube to distribute it wider so more people watch it. Subscribe for the same reason and so that you get notifications when I upload a new video. You can also become a member of this channel for as little as $3. And lastly, you can tip me by pressing the thanks button on any video. All of it helps to grow this community, so thank you. And until the next video.